and here we go. I am super excited this morning. Not legal advice. Like, subscribe, share, comment. Show it to your plants, animals, your relatives, your friends, countrymen. Glad you're here today. Not legal advice. Obviously, don't rely upon anything that is said here today. Today, I'm going to do a menagerie of a whole bunch of stuff. I'll do like, it'll be short and sweet as to each item, but there's a bunch of items I want to cover. But of course, before we get started, this grasshopper walks into a bar. The bartender says, "Hey, there's a drink named after you." The grasshopper turns toward the bartender and says, "Really?" Uh, Bartender says, "Yes." Grasshopper says then to the bartender, "Then give me the stand." Did you hear they arrested the devil? They got him on possession. And last but not least, how many telemarketers does it take to screw in a light bulb? Only one, but it has to do it only during your dinner time. Anyway, so I have a bunch of stuff to talk about, a whole bunch of stuff. So I'm just going to run bang, 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 starting with Alpine. Hard to believe, but in the appeal, there was an additional brief that was filed by Claire, I think Devereaux is her last name. She filed a prior brief. She filed a new brief. She really hates FINRA. So that part was funny. She obviously spent a lot of time. I don't believe the court will necessarily spend a lot of time on her work product, but she certainly spent a lot of time, and I have to give her credit for that. But anyway, that was filed after the last brief. So that was filed sometime this month. Kind of funny. I think December 11th, perhaps, is the date it was filed. And again, next thing on Alpine will be a oral argument that'll be set sometime in 2024. I'll keep you apprised of that, and that's as to GTII. Mark Basile has a couple of pre-petition for the names of defendants that are pending in New York. I filed one that is on appeal. I think the last briefs have been filed, or at least, no, an opposition brief was filed. I don't think the reply brief has been filed. That concerns, I think, activities in the late part of 2022. There's also another one that I think was just argued, a petition, and that one's on appeal. And there's one that was just filed, that was just argued. There was an opposition filed, and I think the argument occurred either Thursday or Friday. And that one relates to activity October 2021 and the initial trading of MMTLP. And for me, that one has a lot more appeal. I obviously am not a New York attorney. I don't know how they will turn out, but if I had to pick, if I was just going to grade, I think the second one has a much better chance of success than the first one. And of course, there's an appeal, which means already that in other words, the appeal has been filed by Mark. Although this one may be successful, the majority of appeals lose. That's just the nature of it. And one of the issues that occurs, or that's at issue in his appeal, is whether the appellate court can look at the facts themselves, or they have to take the facts as disposed of by the trial court. And that's called an issue of de novo. So if you can do it de novo, so if the appellate court says we can look at the factual matter and we can decide that factual matter, that would be better for Mark. This is my opinion, of course, but that would be better for Mark because he can argue the facts which have already been determined by the lower court. If the appellate court says that they can't argue about the facts, then I think it's more likely that the lower court's decision, which was denying the petition in the first case, would be upheld. So that, I think that's a key issue, and that seemed to be a key issue in something I recently read in one of those proceedings. Don't know how the appeal will show up. I know Mark's doing a live stream, I think, or no, Spaces on Monday. He obviously knows a lot more specifically about the cases he's handling, so I won't talk further. But it was interesting because that issue of whether it's de novo or not is an interesting issue. I think it was his argument related to that the trial court didn't make a factual determination and made a conclusion of law, and therefore the appellate court could look at the facts. I thought that was an interesting argument, and we'll see how it goes. But I do believe, by the way, if one of those petitions is granted and there's disclosure of defendants either way, it will be, I think, very helpful and may be useful in a lot of respects. So I wish him luck in the outcome of those petitions. I know he's also involved in the capybara litigation. He filed a lawsuit. Capybara had to the 13th to respond. They did not. The court will now, and I think the court gave capybara additional time. I don't think it was requested, but the court did. Perhaps because they just wanted to make sure that capybara couldn't come back and undo what had occurred. And so that's so that capybara matter is ongoing. The court will issue some kind of judgment for the 20th against capybara. It also, I think, Mark, if it's granted, I think he intends to use it to other media sources to prevent the further dissemination of that stuff. I think that would be a great outcome. I presume capybara is just a fly-by-night, so getting a judgment against them specifically, I don't think that was really the expectation in terms of collection. I think it wanted to stop the dissemination at maybe the publishing level, but that's my view. He may have a different view because he filed it, so I'm just talking. But the way it goes, they've entered a default. So when you file a case, I'll just give you an example in California. File a lawsuit, a complaint, you serve it. Once it's served, they have 30 days to respond. If they don't respond within 30 days, they're technically in default. You can then file some paperwork that says they're in default. What that means is they can no longer respond. Once they can no longer respond, then you can request that a judgment be entered against that particular defendant. Once the judgment is entered, then you can try to enforce the judgment, if it's a money judgment or if it's an activity judgment. In California, you would have generally, within 6 months, you could file a motion to undo a default and default judgment. If you made an error, it has to be excusable the surprise, inadvertence, or excusable neglect. If you assert that within 6 months, the courts almost automatically have to grant that. I don't know how it applies in New York. I'm just saying that's in California. But somebody like capybara, I wouldn't expect, if they don't appear, that they're going to contest it anyway. I think they're a fly-by-night. But again, I think the usefulness of it is to be able to use against media outlets for that purpose. Next, I mentioned Steamroller, about that. I thought that was the more that one has a more appealing feel to me, and I think there was a hearing, and I think the hearing went well. So we addressed that. My MMTLP arbitration, I think I mentioned that I filed about 5 days ago. I filed a recusal motion and a motion for stay. The recusal motion was to get rid of the existing panel, arbitration panel, 3 arbiters, because of their decision making to this point in time. And I specifically pointed to my request for special discovery based upon extraordinary circumstances as defined by the U3 halt, which has extraordinary circumstances. And not only did they deny all, I asked for like approximately 12 depositions. Not only did they deny all of them, but without any reasoning and without any oral argument. So we didn't have a chance to argue about any of those motions, especially in the unique status of the U3 halt, and there was no reasoning for the denial. So for that and very other reasons, I filed a request to recuse the panel. Recusals, that's the legal term when you're getting rid of the judges. And I asked for a stay pending my application to the federal court. So I'm going to prepare something to the federal court, bring them up to date about the status as I see the arbitration, and then we'll see what happens. Of course, I'll keep you updated. I know there's a lot of work going on in Congress. I wish everybody well. My view is, this is my view. So This is just me speaking. I'm not a big fan of Congress. I don't have any faith in Congress at this point in time. So I don't have any expectations of Congress doing anything, and that's been shown. My view. Just again, this is just my view, and I'm not discouraging anybody from doing anything, and I encourage them, in fact, to the extent they have existing relationships and they think they're making progress, do that, because this is just my view. But I don't have any faith in Congress. I don't expect them to do anything. I don't expect, if that the MMTLP matter is not resolved by April, I wouldn't expect anything to happen via Congress in 2024, because we're going to be in the election season. There'll be primaries. I just don't think it's going to be up front. And then there'll be a lot of Congress people who are new, because they'll win or lose election, and we'll have to kind of start the process again, which is fine, by the way. So I think April is the drop dead date, but I believe that without Congress actually generating some type of subpoena where they obtain the records and disclose that, I don't think they're of use, period. But that's just my belief. But I think April, it would be a date to be aware of for Congress. Now, that doesn't mean that MMTLP can't settle or resolve in 2024. I just happen to think it may be through a legal channel. It could be, for example, if Mr. Basile's petition, one of them is successful and somehow certain names are disclosed and that generates some chain of events. I could see that as being the cause of a resolution, but I don't see it absent a change in activity level, subpoena, somebody having some undisclosed relationship with somebody that they haven't taken advantage of to this point in time. I just don't see how Congress is going to do anything unless they do it by April. And again, my view would be, as to all those that didn't help, to do an anti-campaign and get them out of office. If they're not going to be if they're not going to help, I would love to embarrass them publicly during the election season and show how much they were really watching out for the average Joe. That would be my means. So as opposed to being nice, I would be not nice. And I would call them out for screwing retail shareholders. That's my view. So maybe other people feel the same, and maybe after April, May, maybe during the election season, people will have that, because maybe the person who didn't support MMTLP or the cause has an adversary who's running against them that might want to support us. So I really feel strongly that the congressional non-helpers should be called out. My view, personal view again. I know there's a lot of people doing great work. Transparency. So there was talk about the new rule, the SEC, which good old Ken Griffin, that was the start of my the name of this video. He's opposing this. And what this rule, it's Rule 13F-2. It requires managers, which Griffin would apply as, or many of in his firm, who exercise investment discretion, which is a very broad definition. They have to file a monthly SHO, a show form. And I don't believe the form itself has been finalized, showing a certain amount of short sale activity and changes in that activity, self-reported, if certain thresholds are met. They have to report that to the SEC. That reporting, of course, is confidential, so it's not disclosed to the public. And whether the amount and the threshold level depends on whether the company who we're talking about is a reporting or non-reporting company. So is that like a NextBridge hydrocarbons? So this October 2023 rule change, is it directed at because of MMTLP? When I saw the reporting levels and whether it was reporting or non-reporting, it occurred to me that was what they were referring to, but I don't know. It may be, this may have been in the works for quite some time. So how do you determine if someone has to report, file a report, self-report within 10 days, I think after the end of the month? If any gross short position is of $10 million or more during on average during that month, or 2.5% of the shares outstanding of that particular security are being held by that manager. If it's a non-reporting company, then it's just $500,000 of short volume at any point in time in that month has to be reported. And then they have to report basically daily activity and changes in short positions. However, the thing that annoyed me, which kind of says to me, big deal, errors in the reporting can be corrected within 10 days of discovery. So let's say they screw this up or don't report and they say they made an error, or somebody discovers an error, it appears they have 10 days to fix it up. So does that mean they have complete immunity even if they don't do what they should do? It's all confidential from the public. Is it confidential even a FOIA request? And the disclosure to the public will be an aggregated disclosure a month late. So how important and how much benefit are retail traders going to really get? And why is Ken Griffin bitching about it? I know it's going to be extra costs and extra reporting, but big deal in terms of, do I really think anything's going to happen? Where's the remedy? I haven't heard any remedy if you don't comply. So we know you have 10 days to correct, but what happens if you don't? What happens if you intentionally don't file it? Are they going to give you like a $45 fine? It's not even in here. So I'm not impressed. Yeah, further transparency, but so what? That's my view. Anyway, so that's my potpourri for the day. Have a great day. Talk to you later. Any questions, comments, I will address them if some of this or all of this didn't make sense. Take care. Have a great Saturday. Be well. And see you soon. If this stupid thing will